We're going to call to order our first hearing of the evening. This is on the application of William and, is it Talon or? Talon Fish. They reside at 137 Pleasant Street in Milton, and they're seeking two variances from the board. They want to install and maintain a 10-foot by 12-foot by one-story detached garden shed towards the rear of their property at 137 Pleasant Street. The bylaws that I just mentioned call for an 8-foot distance from the sidelines and the rear property line. And here the applicant is proposing to maintain the shed 6 foot 6 inches from the left side property line and 5 feet 4 inches from the rear property line. This property is located in a Residence C zoning district. If you want to come up, Mr. Fish, make yourself comfortable. Let me do a couple of other preliminaries. I've just read the advertisement into the record. We'll also have as evidence at this particular hearing the November 1st, 2016 application, and we have a November 1st, 2016 denial letter. The same day you filed your application, it was summarily denied.
It was.
Okay. And we also have a plot plan for your property by Neponset Valley Survey Associates. It's dated July 11th, 2016, and it shows the subject property, the location of the shed, and the abutting properties, and the frontage being on Pleasant Street. My name is John Leonard. I'm Chairman of the Board of Appeals. With me tonight, to my immediate left is Board Member Jeffrey Mullen, and to my immediate right is Board Member Ted Daber. The rules of the board are such: we'll hear from the applicant, we'll hear from anyone who wants to ask the applicant questions, and we'll hear from people who want to speak in support or in opposition to the application for the variance, if any. We're tape recording the proceedings this evening on Mrs. Fitzgerald's trusty digital tape recorder. That's the official record of the particular hearing, so that would ask that before anyone proceeds, tell us your name and address. Speak up nice and clear and loud, even though we're in a rather small room. There may be people at the rear of the room who want to hear what you're saying. These microphones do not project, they just copy into the videotape. So with all of that, Mr. Fish, welcome to the Board of Appeals. We're delighted to hear from you.
Thank you, and thank you for the opportunity to speak with you tonight. My name is William Fish. My address is 137 Pleasant Street. So the
I'm sorry, could I stop you one question? I don't want to miss this. The board did receive one piece of correspondence regarding this application. It's dated December 3rd, 2016. It's from James P. Belf, and I'll summarize this. He writes in favor of your application to add the shed to your property. He says your family has improved the appearance of the property, especially the rear yard, since you've been here. It looks better now than it has in the 87 years I have been here. Well, congratulations to you for getting this letter, and congratulations for Mr. Belf for his being 87 years in the same residence. So, I'm sorry to have interrupted you. Why don't you proceed?
Interrupt away if you have any more of those letters.
Great.
So, first of all, again, thank you for the opportunity to speak in front of the board tonight. That shed was installed nearly a year ago, and it was done so with no intent to deceive anyone or to be difficult, nor were we trying to undermine the zoning regulations that I have now become intimately aware of. I think what's germane to the conversation, and what I hope the board will take under consideration, is the property previously included a detached two-car garage. And according to the old plot plan, that garage was within 2 feet at several points of the property line and less than 1 foot in others. It was dilapidated, the roof was sinking, it was an eyesore, so we had that taken down. So as the family grew and more space was needed, a shed seemed to be a reasonable solution. We consulted with our neighbors about the idea of who were supportive of our installing the shed. We contracted with Reed's Ferry and installed the 10 by 12 shed, highly of high quality construction.
The Cadillac of sheds.
The Cadillac of sheds, yeah. It was about a $4,500 shed. It matches the house from siding to shingles. We had the shed set up based on the previous placement of the garage, and we did move it in several feet from the previous end lines of the concrete pad of the old garage. And again, just mistakenly assumed that the previous plot plan in the garage placement would have enabled us to do so with the shed. So, it was done. I feel foolish in a way for not having made myself more aware of the zoning regulations prior to installing that shed, and just hope that the board would take that under consideration. That a few feet on either side is good for the family, it's good for the neighborhood, and I think the neighbors are supportive of this.
Okay, so all of your neighbors assent to your application for a
That is my
variance?
sense. I do have one neighbor whom I haven't spoken with immediately adjacent to me. His home was destroyed in a fire about 3.5 years ago, and that property is in disarray. But I think most people know where that house is.
And I assume when you purchased your Reed's Ferry shed, they didn't say anything to you about checking lot lines or distances or getting building permits? Did they manufacture the shed on your site, or
Yes.
did it come?
No, they manufactured on the site.
Okay. And so they presumably didn't run down and get a building permit from Mrs. Fitzgerald or Mr. Prondak
No,
either?
that was-
Okay. Would they live in, are they from New Hampshire, the Reed's
Yes,
Ferry?
yes.
So they figure they can get back to New Hampshire quickly, and Mr. Prondak will never be able to get at them. Okay. Thank you very much. I appreciate your presentation and your candor. Let me see if my colleagues have any pertinent questions for you.
Sure.
Mr. Jeffrey Mullen?
Why are you here? What brings you here? I mean, I know he's asking for a variance, but what happened here? It was up, you were using it?
Shortly upon installation, one of the building inspectors swung by the house and noticed.
Randomly?
That was my response too, yes, randomly.
Okay.
It was during the day that it was being installed.
I see. Okay.
So I can imagine you have the 18-wheeler out in front of the house, and it may have drawn the attention.
Okay. Okay, thank you.
Mr. Deba, please.
When was the old garage taken down?
I believe it was April of 2009.
April 2009, okay. I don't think I
Any
have any.
photos?
I have a photo of the shed, yes. I have the old plot plan too, if that.
Mr. Mullen may be interested in sheds, so we get a good look at this. You pleased with the shed? Is it well-built?
We have 4 children, which obviously comes with 4 children under the age of 9, so the bikes and the games and everything, and even from a functional purpose, to not be storing the snow blower and the lawnmower in the basement of the house has been a safety improvement.
So there's a fence along the back and side of it too, and
Yes.
back of it?
Yep.
and the side of it.
Perimeter fence.
Do you have any other questions, Mr. Mullen?
So is there a driveway here, right?
Yes.
Yeah. And does the driveway go all the way to the back still?
No.
You have grass there now?
There's grass there now.
And where is the dilapidated house that you said that the property owner burned down, or so where is that?
That is to your right of
Right
the
here?
house. Yeah.
Direct abutter?
Yes.
So you didn't speak to the direct abutter?
I mean, I did speak to him at the time when I had expressed the interest in doing the shed, and he, had shared his interest, but I haven't seen him since the notice was.
What did he do? What did he say?
That he was supportive of,
And how about the people in back?
again. I spoke with them directly.
Okay, and where are the people who wrote the letter? Where are they?
They're on the
143 Pleasant
So
Street.
they are two homes down. They're on the opposite side of the home that was destroyed in the fire.
I see. Okay, okay, thank you.
Okay, I don't have any questions.
Are they on the corner of Lyman Road?
They're on the corner of Lyman and Pleasant, yes.
Okay.
He's on Google Earth, that's
I
why
can see
he's
it.
playing around. Okay, let me ask, is there anybody present this evening who wishes to ask Mr. Fish any questions, or otherwise wishes to speak in support of this application? Well, the record indicates there's no such person present. Is there anybody present this evening who wishes to speak in opposition to these variance applications? And there's no such person present. So unless you have something further to add, what we'll do is we'll close the evidence portion of the proceeding. We have to consider this application in open session and vote on it under the public meeting law, and we'll do that here and now. Mr. David, do you want to be heard first?
Yes. I think, particularly considering the fact that there was a prior dilapidated structure there, that this has apparently been built further away from the fence than the structure, and innocently, without realizing that a variance would have been required, or some kind of approval from the Board of Appeals. I think the shed looks like it's an enhancement to the property, and I would support the variance.
I agree.
Variances.
Yes.
I agree.
Do you have anything further to add? No. Okay. Well, I say this. Thank you for your candor. I'm sorry that the Reed's Ferry folk, I thought they were great builders and first-class people, would have gotten a building permit, or at least suggested that you seek that permit, and tell you to check the zoning bylaw to see what the dimensional requirements were. They didn't do it. But that having been said, they're quality builders of sheds, and you have the perfect right to rely on them, and they build a shed there, and they say nothing to you. And that's one cool shed. It's a beautiful shed, and anyone with 4 kids under the age of 9 needs a shed like that for a wide variety of reasons. So I think the application's very well presented. I thank you for that. And I intend to vote in favor of this application. Let me just mention a couple of things. Well, the shed's been built. I usually say that it's got to be built in accordance with plans and specs, but we have it here. When we're going to write this variance, probably take us 10 days, 2 weeks. It's Christmas time and all of that. It's going to be, it's when it gets filed. There's a 20-day appeal period, even though nobody has spoken here in opposition to the application. But once the appeal period expires, you'll get an official copy of the variance, and make sure you record that at the Registry of Deeds so your title is kept up to date, and Mrs. Fitzgerald or Mr. Prondak can help you with that. So thank you for coming. Oh, let's do something. All those in favor of granting Mr. Fisher's application with the usual conditions, please say aye.
Aye.
Right.
Oh, congratulations on the variance. Thanks for
Thank
coming.
you, gentlemen. I
and,
appreciate it.
Good luck.
Really appreciate the time. Thank you.
sir.
I'll write this one, John.
Oh, yeah. Thank you.
10 days. You're not going to hold me in 10 days.
No.
I'm going to London.
Are you really?
Yeah.
Good for you.
Great.
How long?
A week.
A week? It's a great place. Have you been there before?
Never.
Went there on Christmas Day several years ago, 10 years
We're
ago.
going the day after. Was it great?
Yeah, it was great.
I'll be doing it. I'll set up shop. I'll do it from London, just for John.
Okay. Mr. Prondak, good evening. Mrs. McGetrick, you all set to proceed? Want to come up and get settled and make yourself comfortable, and I'll do some preliminaries.
Commissioner, how are you? Good, thank you.
Okay, we're going to call to order our, actually, we have 1 minute to go. We have probably 45 seconds, so you can take your time.
It's like Ginny. I've just been talking to Ginny.
I take my orders from you.
Yeah. You drive by Walter White's house? He's got all these reindeer and Santa. It's funny.
Okay.
Pretty funny.
We're going to call to order our 7:45 hearing, and this is the application of Thayer Nursery of 270 Hillside Street, appealing an enforcement order of the Milton Building Commissioner dated October 6, 2016, in which order the building inspector or commissioner directed Thayer Nursery to cease and desist the operation of a commercial landscape and firewood delivery business at 275 Hillside Street, and to remove all related trucks and equipment for those particular limited uses from the site. The Thayer Nursery property is located in the Residence A zoning district. My name is John Leonard. I'm chairman of the Board of Appeals. To my immediate left is Board Member Jeffrey Mullen. To my immediate right is Board Member Theodore Daber. The rules of the board for this hearing are going to be just like they were for the last hearing. We'll hear from the applicant. We'll hear from people present who want to speak in support of this particular application, and we'll hear from people who have questions of the applicant or wish to speak in opposition to this particular application. We'll tape recording the proceedings, so that would ask that before anyone speaks, tell us your name and address. Speak up nice and clear and loud so we'll have an accurate record of this proceeding. Let me handle a couple of preliminaries. We received some correspondence in the form of emails and letters from various persons. There may be 8 or 10 of them here. I'm not going to read those into the record because, oh, do we have additional ones?
One more.
Okay, thank you.
Thank you.
Great.
And these are copies which you may have, but just in case.
Okay, great.
I think one of those is mine, though. What does it say?
So what I'm going to do is just read the persons who sent us the letters rather than reading the letters themselves. We have an email from Ellen Rogers dated December 14, 2016. We have an email from Caitlin and Andrew Sweeney dated December 14, 2016. Carol Stalker of 291 Hillside Street sent us an email. We have a lengthy email from Paul Krasinski, dated December 13, 2016. Sue Daler, I believe the wife of Robert Daler, has sent us an email dated December 13, 2016, and well, I guess their address is not here on this particular email. Their email address is, but I'm not going to read that into the record. Dr. Martin Dunn sent us an email. Dr. Dunn, I think, is present tonight, dated December 13, 2016. Christopher Van Riet has sent us an email. He's at 106 Hillside Street in Milton. Kim Katz has sent us an email. Kim being, I think, an associate on behalf of Webster Collins, a noted appraiser in Boston. Mr. Collins' address is at 33 Arch Street in Boston. He works for CBRE New England. Mr. Collins also included as part of his email the notice of a deposition that apparently he gave sometime in February. Looks like a Google Maps plan. It's somewhat dark. And a document which is entitled Thayer Nursery Special Permit Mitigation Checklist. Okay, so we thank Mr. Collins for all of that. Kyle Diassi has sent us an email. She's from 225 Franklin Street. That's her business address. Her email is dated December 13th. Andy Cahill has sent us an email. He lives on 325 Hillside Street in Milton. December 13th, 2016. William Koval of Catalyst Restaurant in Cambridge sent an email dated December 12th, 2016. John and Jennifer Balboni have sent us a letter dated December 14, 2016. They live at 44 Forest Street in Milton. Mrs. McGetrick is, I'm sorry, we have one more letter. This is Stephen Davis of 285 Hillside Street in Milton, has submitted a letter in an envelope. It's date stamped by the Board of Appeals on the 14th day of December. Mrs. McGetrick has filed a memorandum with the Board of Appeals dated December 14, 2016. Okay. And Matthew Dunn, the attorney for Mr. Rowe, Mr. Joe Henning. Thank you. Of 23 Parkwood Drive in Milton. And Mr. Dunn also represents Mr. James Cashman of 55 Parkwood Street in Milton. So he sent us a memorandum setting forth his views on the legal issues before us. So let me start by let me do one other thing that Mary suggested. We have a letter from John Thompson, town engineer. And Mr. Thompson, this is so short, I will read it for whatever significance it is, and maybe Mrs. McGetrick can help us with this. He says, the Milton DPW does not issue permits for work within the town's right-of-way between the dates of November 5 and April 15th of each year, excluding special circumstances and emergencies. So we thank Mr. Thompson for his kind note. As the advertisement indicated, this is an appeal from a cease and desist letter of the building inspector. In the building inspector's letter, which is lengthy, and I'm not going to read it, but for those people who are watching on TV or here just to hear the proceedings, has cited Thayer Nursery and ordered them to cease and desist not from the nursery business, but for three particular categories: to cease and desist from commercial landscaping business, to remove the landscaping trucks and equipment from the Hillside Street, and to cease and desist from firewood delivery business until the conditions in the special permit have been completed and until Mr. Prondak has issued an occupancy permit certifying that the mitigation measures have been completed. So that's the limited issue we're here for this evening. We're not here to rehash the history of Thayer Nursery and the neighbors. We're directed to these specific, rather succinct issues. And it's always a pleasure to have Mrs. McGetrick back before the Board of Appeals. Welcome back to the board, and we're delighted to hear from you.
Oh, thank you very much. It's great to be here. My involvement in this began at about mid-October, after the enforcement letter was issued, after the board had apparently had a hearing on a prior enforcement order and had issued a decision on September 30th, 2016. The Oldfields engaged me to meet with them and the building commissioner to determine what remained to be done in order for them to be in compliance with the mitigation conditions in their new special permit, and to decide what the procedures should be going forward in view of the existing enforcement order. And so I have a letter. I'm going to talk about most of what's in it, not necessarily read it to you.
Thank you.
I want that to refer to. I just reviewed in the beginning of the letter what you just reviewed, which were the major issues in the enforcement letter. But the reason I'm here today is to go over the requirements in the Board of Appeals special permit that related to work that had to be done on the site in order to provide protection against the issues that you actually referred to in your September 30th decision.
And you mean
For
you mean the planning
example,
board,
issues of
Mary?
noise, I'm sorry.
You mean the planning board special permit?
No, I mean, because in your September 30th decision, which was not about the new special permit, you did have a paragraph talking about the new special permit, and you provided some information that I think was useful to the applicants by, first of all, saying that you agreed that they had to complete these conditions in order to receive an occupancy permit and to be in operation under the new permit. So, at that point, they then focused all their efforts pretty much on completing the conditions that they had not completed. And that's what they've been doing since that time. Now, the problems that the permit addresses that you list in your discussion on September 30th are noise, dust, odor, light intrusion, and stormwater runoff. These are all issues that the planning board tried to address through the new special permit by imposing certain special conditions. Some of them are operational conditions. Some of them have to do with maintaining no more than the workforce and the trucks and so forth that were there in 2012. And some of them are actual physical changes to the site, and there are a lot of them. And there are a lot of detailed conditions. So what I propose to do tonight, what I've done is prepared two documents for you. One is this letter simply explaining.
I'm sorry, Mr. Mullen has a question.
Sure.
Marion, when you were reciting what we wrote in our permit,
Yes.
our decision, where were you reading from? Was that page 7?
It's later on. I know it's really more in the nature of a comment because the decision
Okay,
wasn't
so it
actually
wasn't
about the
verbatim, you
special
were
permit.
just summarizing what we wrote?
Summarizing.
Okay, thank you.
Could I ask you one more question before you get into your...
Sure.
And that is this mitigation checklist that was attached to Mr. Webster Collins' letter. I mean, is this something that Mr. Collins prepared, or is this something that Thayer Nursery has...
Well, I'll look at it, but let me explain to you. I have provided you tonight with a report, along with my letter, on each of the mitigation conditions and what the status of the work is. I've also accompanied the building commissioner and Josh and Maggie Oldfield yesterday on a site walk at the property to view each of these work areas and to talk about what had been done, receive any comment, critique, so forth, from the building commissioner. So I think what I would suggest that we work with as we discuss this
Is your letter.
is the second letter, which is what I call a report. It's a report on compliance or the status of compliance with all of the conditions that are in the special permit. So if you look at the second letter I've given you, you'll notice that it lists categories of conditions.
Yes.
It lists a page next to the category. That's the page on the special permit from July 15th. And if you need copies of the special permit, I did bring, you
No,
don't.
we have enough copies. No.
I'm sure I thought you must have them because you had already talked about it previously. But that's to make it a little bit easier. If I summarize what the conditions are, I sometimes quote. But if you want to go back and look at the special permit, that tells you what page that
Great.
section is on.
Thank you.
So let me just make sure I've covered the main parts of my letter. Just in general, before we get into that review, after your decision and the visit from the building inspector and the enforcement order being issued, applicants have been, worked very hard to complete what was not completed. They've met several times with the building commissioner. I met with him. And the decision was made that they needed to appeal the enforcement order in order to be able to come back to you and explain to you how much had been accomplished of these conditions, which that kind of review has not occurred to date. And a lot of work has been done since your decision in September, or your discussion in September. So I just respectfully request that you review the report. We'll go through it tonight, and it's my hope that you will determine that the applicants have substantially complied with the conditions of the special permit, keeping in mind that these are the conditions for altering the site. There are many operational conditions in the special permit which will come into effect if they begin to operate under the special permit and must be complied with going forward. And they're detailed and complicated, and they will be an ongoing task for the applicants, and I hope not, but I expect from time to time by the building commissioner. So tonight, I just want to talk about the work that had to be completed before the permit can take effect. So going to my second letter, which is the report, there are general conditions that apply to the site, many actually, but basically they have to continue to have the same number of employees as in July 2002. These conditions all relate to the landscaping business, snow removal in the winter, and the delivery of firewood, which was considered part of the landscaping or business that was at issue by the planning board. So same number of employees.
Is the purpose of that so that they don't end up having 25 or 30 employees on the premises? Or
Well,
it seems like an extraordinary thing to put in a special permit to start to.
It is unusual, but what the planning board tried to do here was to keep the business at the same level that it was, where it was operating in July in 2012.
Could they have?
So there
could
are
they have 15?
affidavits that have, I'm sorry,
Could they have 15 employees if they
they
wanted?
could have less.
They could have less, but
I
not more.
probably shouldn't have put it this way, but yes, 19
I don't know how they put
fewer.
it. I assumed you're
I think
copying what they said. Just-
There are affidavits and there are tables in the decision that actually list the number of employees that they had
Okay.
in July 2019. There also is a long 3-page table that lists the vehicles and the equipment that are on site. And although I didn't show that in my discussion because it wasn't necessarily pertinent, the permit also distinguishes between vehicles and equipment that are used for all of the business operations, including the nursery, and those that are used only for landscaping. And the reason that's important is because if they can't operate the landscaping business because they haven't complied, then those particular vehicles can't be used on the site until they have complied.
Yes.
So those particular vehicles are identified by the make and the truck and, everything. The building inspector can tell which ones they are. They set a limitation of the amount of materials that could be stored on site, and these are things like mulch and loam and stone. Again, that amount can't exceed what was stored in 2012, and it's all detailed in the permit. The planning board decided that they would be permitted to process no more than 1,000 cords of firewood per calendar year, which was actually a little less. I don't know what the number was, but it's less than they were processing in 2012. And then finally, the permit generally says the landscaping use can exist on the lot with other uses, including agricultural, greenhouse, nursery, and residential. So moving on then to the specific conditions, I'll begin with the land care yard. That's page 7 on the permit. And one of the conditions was that there could be no more than 6 bins holding material, and the material, again, is the loam, the mulch, and the stone, and any material used like that for landscaping. The dimensions for each bin are specified, and the location is generally identified as in the land care yard, which is a particular section of the site which is shown on plans that we have. In fact, they're right here. Presently, there are no materials like this on the site, except for a very small amount that's being used to do the work, the mitigation work. So we met with the building inspector and discussed this, and in October, late October, we met and discussed what the bins should be made of and exactly where they should be located, and the fact that sprinkler heads had to be installed so that they could sprinkle these bins when they are put in place. And the building inspector suggested that they should install the sprinkler heads now, or have them up, that the bins would go in, they had to be in before they could store any materials. So presently, there are no materials, there are no bins. That's a condition that still has to be fulfilled, but these bins are sort of temporary. They're made out of stone block or other material. They can be taken up and put down. So the situation is the bins aren't there. We know where they're supposed to go, and they can't go. They have to go in before any material can be delivered to the site in the spring for landscaping. That's, I believe, I don't really know how they've operated in the past. Maybe they have had piles of material in the past, but currently they don't. The second area, and the sprinkler heads there are sprinkler heads located in locations that we reviewed yesterday so that they could be available to deliver water. And this is actually an area of the site that was used before for growing, so there were water lines already installed. Not a great difficulty doing that. The second issue is the grow-out area This is work that has been...
I'm sorry, Mary.
I'm sorry.
Mr. Mullen had a very good question, and that is, this is fairly long and detailed, which we appreciate. I'm not being critical. But Mr. Mullen is suggesting that maybe if we have questions on, as you go through these sections, we should ask them when you're going through that section, because if you go through 12 sections, we won't remember what number 2 was. So do you have a question on the bins or
I do.
sprinklers?
Yes.
I do.
Fire away.
What about the washed stone? Is that on the site now?
There-
The yard surface of 3/4-inch washed stone, that's not
Yes,
there
the
either.
site is prepared. Is that the surface of the site or the storage?
Well, there was a requirement, it's in the top of your letter, reciting the requirement that was in the special permit. It was bins and surface materials to prepare the site for the materials, and the requirement for the yard surface was 3/4-inch washed stone.
I think that's already, that's the, I believe that's already been
Commissioner
done.
may know.
I believe that's completed and
That's
in
on the
place,
site,
so it
okay.
doesn't have to be stored.
So in this category of the land care yard, getting into the first category of the specific conditions, the bins are not there, but the surface materials are.
Yes.
Okay, thank you.
The grow-out area requirements were to remove 10,000 square feet of impervious surface, that's pavement, I believe, replaced with loam or similar material, not loam, and create new nursery stock, a new area for growing nursery stock to be irrigated with overhead sprinklers and could also to be hand sprinkled to control dust. Of course, there's nothing really growing now, but the work has been completed. Both of those steps have been completed. Fence and related plantings. This is a huge part of the mitigation work. If you were to look at the site, you would see, and I've provided a plan here for you to this is a sketch that I asked Josh Oldfield to prepare. These are copies for you, so if you want to just move them up there so you can see them, and there are extra ones here if anyone wants to look at them, but without
Do you want one of these?
being totally specific, I'll say that the fence area is marked on this plan by the colored lines, and there are little red X's all along the fence area. So the entire fence structure has been installed. And on the fence, it's a detailed description, you have it in front of you, I'm not going to read it, but basically this is a very high fence with a wooden frame and a frame between the wooden areas that supports a sound suppressing material that sort of that you can unroll and then you lay and attach against these big squares. So when you look at the fence now, you see wooden edges and you see this green material that's laid against it. That's what actually suppresses the sound. So the fence is completed. This area here where it's yellow is the only area where they have not completed installing what is it called?
Sound attenuation.
The sound attenuation material. And the only reason, they haven't stopped, but you can only do this installation when it's at least above 30 degrees, probably should be a little warmer, because it has to be unrolled, you have to let it warm up, and then you have to, in order to be able to install it, it has to be a little bit warm. So what I said in this section was, as far as the actual fence goes, they are continuing to finish putting the material on as they're going to be able to, weather conditions permitting. If it's very cold, of course, they can't do it. If it's above 30 degrees, they will probably be able to continue, and they have been working on it, because in the wintertime, they have more time to do that. So as far as how much of the fence area it is, it's less than a sixth of the length. I didn't actually measure it, but what I can tell you is that this part of the fence is behind some buildings. It's at the end of the land care area, and it's not an area of huge contention in terms of the noise mitigation problem. And I think one of the letters you have is from Mr. Cashman. I haven't had the opportunity to read it. I believe he is not upset at it not, that last piece not being finished yet. I believe he would have preferred to have no fence, but, you know, that's not his choice, because this is a special permit and they have to meet the conditions. And there could be other people who'd move into the property and would want the fence anyway, so it's just, it is what it is. There are additional requirements that relate to the fencing having to do with plantings that had to be done all along the fence area, between the fence and the neighbor's lot lines. And the planting requirements were quite specific. I've listed all of the trees, evergreens, rhododendron, mountain laurel, and other plants that were supposed to be installed, and I think I listed the number of each. I also can report that a member of the planning board visited the site and reviewed the actual plants that had been selected, and the choice of plants, and was happy with them. And this gets as specific as, you know, they had to be native plants, and if you choose plants that can pollinate each other, that's better than plants that can't, and that kind of thing. So, quite specific. We did review.
Was that an official visit, by the way, by the planning board member, or was he just?
Cheryl Tagayas made an official visit,
Okay.
but, you know, I don't know how you relate it to the permit. I mean, she just agreed to come and look and
Okay.
tell them, you know, that she was most interested in that particular aspect. On the fence itself, they also completed installation of 3 access gates. There are huge gates on hinges, so you can open the fence and get in and out. So we reviewed the plantings with the building commissioner. The applicants followed the description in the permit, plant by plant, but they actually did plant a few more trees and a few more bushes here and there. And it seemed, I believe that they have planted everything that they're required to plant. Let's see what else. The trees are all of the, you know, the requisite height. There's a stone wall supporting a long length of the fence along here. It's not a stone wall, it's actually it's more elaborate than that. It's a very attractive wall, you know, that supports the bottom of the fence. And that's completed.
Excuse me, Mary.
Yes.
Is that in the area then that's marked in green? That's where the wall is, or?
Well, it happens to be the same area as where the drainage work is.
Oh, it's where the
The blue is drainage work, the green
Oh,
is
okay,
all the
blue.
completed fence. But you're right, it's, well, actually, you can see it. See, extend existing wall at elevation 184. That's the wall I'm talking about. They're little round
Okay.
stones, kind of shown on the drawing. Okay, so the next area of
Before
mitigation
we
is,
leave the fence,
oh, sorry. Did you have a question?
would it be okay if the building commissioner reported on I know you just said that.
I think it's absolutely up to
Yeah.
you. That's-
Could we hear from the building commissioner about the results of the planting and fence work inspection yesterday?
Sure, of course you can.
Good evening, Joe Prondak, Building Commissioner. I did visit the site yesterday, myself and accompanied by Tim Krasinski from the Assistant Planning Director, at the request of Thayer Nursery and Ms. McGettrick. And I think the simplest way to put it is I've reviewed Ms. McGettrick's review of what we saw yesterday, and I do concur with her.
This is the review in the so-called second letter,
Yes.
okay?
The sound attenuation material, the fence has been put up, the fence structure, which is wood post, steel mesh, wood cross members with a sound attenuation material attached to it. The entire fence structure has been put up. The sound attenuation material is complete with the exception of the last 130 feet or so from about the front of the parking area, so to speak, toward Forest Avenue. The plantings have been installed, to the best I can tell. I mean, I don't really know the difference between a rhododendron and anything else, but there seem to be some discrepancies in the plan That was approved by the planning board and the written document, but if you count the trees by the written document, or count the number of plantings by the written document, it does seem to comply with that. The crushed stone has been down. The bins, as Ms. McKittrick stated, are not in yet. However, there's no material to be stored. And I think that's
Thank you.
basically it.
Can you, can we accept where the applicant has marked this drawing? Is it fair to say that the, I know this isn't an as-built plan, but it is a proposed conditions plan. Are the conditions as shown on this plan, is that the condition of the property now, except as marked? Or am I going too far in saying that?
No, I think
I think
that
that's
is
right.
correct.
I mean, that,
Yeah,
yes,
that's
that's the
correct.
detailed site
Okay.
plan for all the work.
Okay, okay.
And the reason we marked it was there were
Just to
certain
show the
areas that had
differences.
to be completed, and we wanted you to see clearly
Okay.
where those were.
I have no,
And-
No
and
questions.
If I may, one other important feature was the drainage had been completed up to about the beginning of the Cole property along the back of the, up to this point here. The remainder of the drainage, system is.
okay, thank you.
On the, okay, so the drainage mitigation was the next section, and I did want to add to that Josh Oldfield reported that he has done an additional 80 feet of the, let's see, what do you call it, the regrading, so that the drainage that is designed to direct flow in a direction towards the street, not towards neighboring properties. It's a very slight grade, it's a 1% grade, I think. And it's supposed to end with a sort of a drainage basin, which is near the street. And that, there is supposed to be a connection between that drainage basin and the storm drain in the street. The town is requiring that their nursery run a pipe under the stone wall and out to the street. And they're also requiring that the work not be done until April, because they don't want street openings unless it's an emergency this time of year.
Yeah.
So the drainage work, so I guess I said here it had been done except for 100 feet or so, so about 80 feet of that were completed today, which is a good thing, excuse me, a good thing, because tomorrow it's going to get colder, and they want to have this drain incline completed. It's just, sort of preparing the land so that if there is water runoff, that it will run off in the right direction. And there is a pit that's been dug, but it will probably be improved before, when they put the pipes in to connect to the street. So to the extent that they've been able to, they've completed this drainage mitigation work. The only thing preventing them from making the connection is that in the winter, you can't open the street to do the pipe connection. Once the drainage work is complete, then Thayer, on this particular point, has to submit a letter to the building inspector from a licensed engineer or someone who can certify that they've built the drainage as it's shown on the drainage plan. That's one of the attachments to the planning board's decision. So that will be a condition on any, I guess, occupancy permit or anything that's issued. Vehicles were not, there weren't changes proposed to the vehicles, but we did an on-site, I accompanied the building inspector and Josh and Maggie Oldfield to inspect the vehicles that were on site, and also to talk about that vehicle requirement, to understand in particular detail just exactly how restrictive it is, and to make sure that the applicants understand that if they wish to buy a new truck, first of all, they can't exceed the number of trucks and equipment that they had in 2012. There's a 3-page list of those in the special permit. If they wish to replace an existing piece of equipment or an existing truck, the replacements have to be very similar to what they currently have. And, size, type, and capacity is the way it was described in the permit, and it's the way the building inspector described it yesterday. That's pretty specific. So, it probably doesn't have to be the same model, correct me if I'm wrong, but it needs to be the same size, it needs to be similar in terms of its weight-bearing capacity, right? And so that's something that's going to be an ongoing process to monitor that and make sure that they're complying. I believe at the present time, when we looked yesterday, that the vehicles that should have been there were there. There were a couple that were being used for work on the site, but they were there on the site. They don't have to keep them on the site, of course, but they can't keep any more than this number on the site. Any questions on vehicles?
No,
Okay. On firewood.
we're not bashful. We'll speak up if we have
Yeah, I'm
questions.
sure. The firewood issue is deliveries of firewood, and it's a noise issue, safety issue, and so on and so forth that came up in the course of this permit application, and even in writing the zoning, and also, I'm sure, in the prior orders relating to existing special permits and work. The first thing the Board of Appeals did was say that they couldn't process more than 1,000 cords of wood per season. So we're sort of at the beginning of a season. At the present time, at the time we looked, there were estimated to be about 15 cords of wood in the barn. There is a requirement that the truck, the large truck that would be used to deliver wood from Thayer Nursery, has to have a rubber truck bed in it that's designed to absorb noise. So there has been some kind of rubber truck bed installed in the truck, and well, the building inspector can report on that if he hasn't, wants to say more about it, but it's there. He was tall enough to get up to see over the top of the truck. I couldn't see it, so. One of the things that Thayer does in the wintertime is snow and ice removal if needed. Last year, they probably didn't do much business, but the year before, there may have been a lot. In any case, the permit, again, in this regard, limits them to no more than the number of vehicles that they used for snow and ice removal in July 1st, 2012. I'm not sure I found that number in the special permit, but there's probably an affidavit that was filed that does state what that number of vehicles was. And the same condition applies to the number of employees to be used in snow and ice removal operations. There are also a lot of operating conditions relating to everything they do there from here on, but they include conditions relating to this, and they relate to where the equipment is to be stored. The hours, there's some flexibility in hours during a snow event, but the rest of the time, the hours have to be observed that are in the normal permit. The snow and ice operations can't commence without an occupancy permit for the uses allowed under the special permit. So one reason we're urgently here today, even though it's winter, is that there are two things that their nursery does in the winter. They sell wood, and a lot of people come, and they can do that now. They come and they load up wood into their cars or their vehicles, and they take it away. And business has been extremely heavy in that regard because they're not getting big deliveries. But people do want the deliveries, and so one reason to ask you today to review compliance is to try to see if they're ready for some kind of substantial completion of these conditions, and then would be eligible to apply for an occupancy permit with conditions for anything that isn't. Okay, the next topic is lighting. The permit, there's not a really long section on this, but this is actually quite similar to many other permits that I've seen, where the lighting is required to be shielded and can't shine onto adjoining properties. And it's really very specific in this permit. It says they have to be directed downward. There has to be a cover shield installed so they won't be visible off-site. So when you look from a neighboring property, you're not supposed to be able to see the light bulb or the light fixture. The lights have to be turned off at the end of business, except for lights along the driveway and granite posts. They could have security lighting, but they need to get approval of the planning board for that. They don't have it right now in any particular way. So this is the present situation. They did have permanently mounted lighting fixtures, and they used these in this time of year to sell Christmas trees. So they used to have big, these lights were bright and they really shone over the whole area. They went to their lighting contractor and asked him to install shields in the lights, and they were informed that there are no shields available for these lights anymore. They're older lights. So they made the decision to have no lighting. They didn't put any lights in that area, and they managed this year. It was a little dark. I bought my Christmas tree there. And they would next year in order to have lighting there, they're going to have to install entirely new lights, and the new lights are going to have to comply with the requirements in the permit. So again, they have to be directed downward and shielded so as not to be visible off-site. And it also says in the permit that light levels have to be kept as low as reasonably practical, which is something you see a lot in these permits now. So no brighter than they have to be, and that's something the building inspector would be involved in reviewing. There is one light on the side of a building that overlooks the land care area, which, let's see. Well, the land care yard is on this plan. You can see it here. And that light is high up near the roof peak, and it shines straight out. I think there's 3 of them. They're really spotlights. So they're not suitable under the conditions of this permit. And we discussed that yesterday, and the applicant said they're just going to have to not use them. So they can easily purchase alternative lighting, well, fairly easily, and it shouldn't be too expensive, that will shine down, that will probably be placed lower down in the building, but will still provide some lighting. So when they enter the premises at the beginning of the day, when it's still dark a lot of times, they'll be able to switch this light on and, be able to see where they're going. But for the time being, they won't be using that light. Present practice is, Maggie Oldfield turns the lights off at night. Josh Oldfield turns them on early in the morning when he arrives to get ready for work. So, in summary, I guess I would say, as you noted in your September 30th decision, September 30th, 2016, the July 15th, 2016 special permit conditions are designed to mitigate noise, dust, light intrusion, and stormwater runoff to protect neighboring properties. The applicants have completed all or almost all of the site work required by the special permit to mitigate these conditions, but the exceptions are the connection to the town storm drain, which cannot be completed in the winter, a small section of the sound suppressing material at the end of the new fence, which can only be installed in conditions above 30 degrees Fahrenheit, and the storage bins, which will not be required until new landscaping materials are delivered in spring 2017. The remaining sound material will be installed on the fence as soon as possible and dependent upon temperature. The storm drain connection will be created as soon as the town permits it, the street to be opened up in the spring. And the storage bins will be installed according to the building commissioner's instructions prior to any deliveries of materials to the site for landscaping in the spring 2017. And presumably, if you determine that they have reached the point of substantial compliance, they will then apply to the building commissioner for a certificate of occupancy, and he will decide whether to issue one and under what conditions. Because I suppose the building commissioner also has the option of a temporary certificate of occupancy. So it's not unusual with other types of structures to have something that hasn't been finished or needs to be redone. And so conditions are not unusual in that certificate of occupancy. But of course, the nature of the condition depends on the nature of the work required, or the work that has to be done. So that concludes my summary of the work that has been done on the site. You have letters from neighbors, and neighbors, of course, many neighbors have been very supportive. They may not understand all the details of the site work that had to be completed, but, I mean, we know they support there, and that's a good thing. But the important thing is to understand these conditions, to be able to absorb what's in that permit in detail, to review what's been done thus far, and to decide whether this meets the standard of substantial compliance. And I certainly respectfully request that you consider making that determination tonight. And that concludes my remarks.
Great. Let me see if there are any catch-up questions. Mr. Mullen, do you have any follow-up questions? Mr. Daber?
No, I guess I think you said it, but your assessment is that that's an accurate summary of the conditions of the property and the compliance with the various
Correct.
Mr. Prondak. Okay, thank you. Yep.
Okay, well, thank you very much, Mrs. McGettrick. Let me ask Mr. Prondak, other than what you've said up to date, do you have anything else you'd like to add?
I don't think I do at this point.
Okay.
Other than, this board issued a decision, and my enforcement order the decision was not appealed, and I subsequently wrote my enforcement order. After that final appeal period had expired, essentially telling, there was, yes, a cease and desist order, but also telling Clay Nursery that they need to comply with all of the conditions. And I guess there should have been a definition between the physical conditions and the operative conditions. I didn't make that determination, but that's what the letter was directed at. But they would have to comply with all of those prior to receiving an occupancy permit. And that's
Okay. Does Mr. Mullen, do you have any questions of Mr. Prondak? Mr. Daber?
Sir.
Okay, well, thank you very much, Mr. Prondak. Let me ask Mr. Dunn, do you want to be heard?
Sure.
Why don't you come on up and make yourself comfortable? You can stay there, Marion, if you prefer, or just slide over and let's have the microphone and for Mr. Dunn to be heard. And
Good evening. Matthew Dunn. I'm an attorney. I represent Phil Joining and John Rowe of 23 Parkwood Drive. I also represent James Cashman of 55 Parkwood Drive.
Good. Welcome back to the Board of Appeals, Mr. Dunn.
Thank you. Thank you.
Delighted to hear from you.
I guess the primary opposition to the present appeal before the ZBA is procedural. As the members are aware, we were before this board back in August and September of 2016, at which time the ZBA issued a decision dated September 30th. In that decision, which was not appealed to either the land court or the Superior Court, the ZBA indicated that it is the board's interpretation that the mitigation provisions of the 2016 special permit must be substantially completed, and the applicant, pursuant to Section 8C of the Milton zoning bylaws, must secure an occupancy permit from the building commissioner in order to use the subject properties for commercial landscaping purposes. Now, this seems to indicate that there would need to apply for an occupancy permit with Commissioner Prondak, and in that it would be Commissioner Prondak's role under 8C to certify whether there's been substantial compliance with the provisions of the special permit. Respectfully to my sister, it's not for her to come before this board and plead that there's been substantial compliance. It's a determination for Mr. Prondak to make pursuant to an application that's filed by Thayer and a full site inspection to make that determination. After he makes that determination, if Thayer is aggrieved by it, that's when the Zoning Act 40A Section 8 kicks in. And then Thayer would have 30 days from the date of that decision to appeal to this ZBA whether or not an occupancy permit issues. This ZBA could then, Mr. Prondak could present his findings to the ZBA as to what was his basis for the decision, at which point this board could make a decision as to whether to uphold his decision or overturn his decision. That determination by this board could then be appealed by either Thayer, if they were to be aggrieved by it, or by the abutters, if they were to be aggrieved by it under 40A Section 17, which would then go to the Superior Court or to the Land Court. So what we're sort of doing here is putting the cart before the horse. We're having a request made by the applicant for a determination of substantial compliance, when respectfully the ZBA has already made the decision that determination rests with Commissioner Prondak. And so, therefore, the issue of substantial compliance is not really ripe to be decided by this board, and it's not procedurally proper to be before this board to make that determination. What we need to do is go back Thayer needs to submit an application, again. Mr. Prondak needs to make the evaluation, make the determination, and then, who knows? Thayer could be happy with this decision, and they're not the ones who appeal. And maybe it's my clients that are aggrieved by that decision, and we utilize our rights under under 48, Section 8, and bring an action or an appeal before the ZBA, and then, we go through the procedure that I discussed previously. But to go through this exercise right now without having this board having the benefit of walking the site, having the special permit, which is extremely detailed, it incorporates a number of site plans and a number of conditions, which, by the way, were not appealed by Thayer. Thayer was a participant in the hearing process. They're the ones who helped formulate the very conditions that they're complaining of right now. So those conditions are binding as part of the bylaws of the town. And so this board has determined that they require substantial compliance, a decision to be made by Commissioner Prondak, and then to follow the procedure that we've talked about. So, like I said, respectfully, and I appreciate the presentation that my sister's made and the consideration that this board has made, but procedurally, we're not here properly. And this proceeding, I guess, should be either dismissed or suspended until we go through the procedures that are, it's pretty clear, what steps 1, 2, 3, 4 need to be followed in order to make this decision, to have it even be, effective should it ever be challenged. So, just based on that, and those are the majority of my client's opposition is set forth in my letter that I submitted to this board today. But just to point out that, again, that those conditions are binding upon Thayer. Thayer didn't appeal them; they were part of the process, and now we have to let the process play itself out the way it's supposed to play out, and the way that I think that this board envisioned it playing out when it issued its September 30th decision. So, for those reasons, like I said, I'd ask that the board either dismiss the instant appeal to the extent that it doesn't specifically address the cease and desist from Mr. Prondak dated October 6, 2016, or suspend it until such time as we go through the steps that we need to do.
Mr. Dunn? Mr. Mullen? Mr. Neighbor?
No.
Okay, well, you've made your point rather clear. You prefer not to discuss the substance of Mrs. McGettrick's presentation at the present time.
Well, one thing that I was specifically asked to present to the board is Mr. Cashman's insistence that all the requirements of the special permit, that either the 2015 or the 2016, whichever one is in play here, be followed by Thayer as a condition precedent to it being allowed to resume any of the commercial activities. He's not, to the extent he even could, he's not waiving any of the protections that are afforded to him as an abutter, nor are Mr. Joenning and Mr. Rowe. And it's their position that, they obviously live next to the property. They have a site view of it on a daily basis, and it's their position that there hasn't been substantial compliance with the requirements, at least with respect to what they can observe from their own property line. So.
And they own the portion of the property where the fence has not been completed.
They own the portion of the property that's actually highlighted in red.
Yep.
And there's an issue about the,
Specifically, this part.
Oh, okay.
Yeah. So it looks like the fence is completed there.
It is completed there.
Yes.
Oh, okay. All right. I had the misimpression that, you know the prior owners to the Cashmans?
Pamela Pori.
Yes, that's what I thought. I had the impression that her property was
But
on the right side.
what needs to be pointed out is the construction of the fence doesn't necessarily mean there's been substantial compliance. The whole point of the fence was to create sound mitigation, a sound barrier, which requires some additional mitigation with regards to, on the fence itself, what needs to be put on there. So
Yes.
the actual physical presence of the fence doesn't accomplish what the planning board intended in the special permit for it to accomplish. So There is a
I don't know about, I mean, the building, we just heard the building commissioner say the opposite, so, I don't know what to say. You just said,
It's supposed to be sound attenuation.
you just
right?
said the sound attenuation's there, Matt. Just said it.
These guys live there.
Building commissioner was there, he's the building commissioner. It's just, the plan is either accurate or it's not accurate. This plan shows that the fence and the sound attenuation is up in all of the area covered in green, and the building commissioner said that was accurate. What is it? Is it in there or not?
The sound attenuation is
Okay.
in the area covered in green. I was there yesterday.
Is it certified sound attenuation? Because it doesn't block any sound.
That may be a different issue.
Right, I mean,
I'm
this one's-
confident that it is the correct material.
Let me talk over people, but-
I will get that
But
verified.
the issue, right, whether there's substantial compliance, requires you to go down at this, multi-page special permit with extreme, that it has details in it, and go through and say, all right, well, the fence is built, check. Does the fence have affixed to it certain sound attenuation material that is compliant with what is required under the special permit?
Yeah, but you're saying that only happens after
He goes on-
we dismiss this appeal and they...
He goes, there applies.
That's what you're saying.
Commissioner Prondak goes back with a checklist and goes through and says, items 1 through 165, of those, 148 have been complied with.
Right. Okay. Thank you for your presentation.
Thank you.
We might as well see if there's anybody else who wants to be heard. Mr. Joe Henning, do you want to be heard?
Yes, I do.
Sure. Why don't you just tell us your name and address for the record?
My name is Phil Johanning. I live at 23 Parkwood Drive.
Good. Welcome back to the Board of Appeals, Mr.
Thank
Joe
you,
Henning.
Mr. Lyon. I guess I have to say, I've had it up to here with all these shenanigans, and it has to stop. There was an entire year that has gone by, and now we're talking about how we can't connect to the town sewer because it's too cold. There was an entire spring, there was an entire summer, and nothing was done. And now we say we can't complete it because it's too cold. It's outrageous. Additionally, before the planning board, and I attended every single meeting for over a year, there was a discussion about what the special permit, what the bylaw amendment said about the distance between the fence and the abutter's property line. And I believe that the fence behind the Tevens home is at 9 feet, and it is not in compliance. And I think Mr. Prondak knows that. There was a conversation about how the Tevens agreed. The Tevens don't have a right to agree. The bylaw amendment is the bylaw amendment, and the bylaw amendment gives the distance that it has to be located. And I, as an abutter to Tevens and there, have an interest in where the fence is placed. And the fence has to be in accordance with the bylaw amendment, period, end of story. Additionally, I don't really care about Cheryl Tagayas's thoughts on landscaping. That also is defined in the bylaw amendment, and it has to be as specified. And so, John Rowe and I live in the town in compliance with every bylaw, zoning bylaw. We violate none of them. We have not affected our neighbors in any way. I have not even gotten a traffic ticket in the town of Milton. Yet, my neighbors continue to violate the zoning bylaws with abandon. And I say that because Mr. Prondak found evidence of that when he visited, and he states what those objections were in his letter, his October letter. And I know, and John Rowe knows, that the wood delivery operations continue. In Mr. Prondak's letter, there's evidence, and Maggie and Josh have both admitted that they continue to operate even though the mitigation that was promised to me by the town meeting has not been accomplished. They should be in Quincy District Court on contempt charges, but the town does nothing to protect me, nothing. And I'm getting very tired of it, very tired of it. I live in complete compliance with the laws of the town, and others do not. And I receive no protections, and I'm perceived to be a problem. I'm not the problem, and I want to make that clear. I am not the problem. I am living in compliance with all the zoning bylaws and all the other laws of the town, and it's about time that I receive the protections that I'm entitled to, that were granted to me by town meeting. And I ask you for those protections. I ask you to ensure that that drainage system that was meant to protect me and my property is installed complete. I don't care that it's gotten cold. It wasn't cold all summer, and it wasn't cold all spring. It could have been accomplished, but it was not. And I think it's time now that we get it finished. And if it's not finished, I believe that you cannot issue an occupancy permit. It's not about substantial. It's about 100%, because the drainage was all about me and John Rowe. We asked for the drainage, and it was given to us by the planning board. We made sure of that. Until it's finished, it's not finished. And if it starts to rain and it starts to snow and the water starts coming into my basement, which has just been repaired, then I have another problem again. That fence that's at 9 feet needs to be in accordance with the bylaw amendment. That's what Mr. Prondak is obligated to ensure, that it is exactly in compliance with the bylaw amendment, and it is not at this moment. And Mr. Stevens, he told me he made no agreement, but nevertheless, he doesn't have the right to agree with another party to violate the bylaw amendment. The bylaw amendment is clear, and it has to be enforced. That's it. That's the end. So I just ask you to please afford me the protections that the town intended me to have. And until they're 100% complete, there should be no excuses. And if an occupancy permit has not been issued, I don't see the purpose of 50 cords of wood in that barn. If there are 50 cords of wood in that barn, it's exactly for the reason that I've said. That wood delivery business has continued unabated. And I think that the applicants so much as admitted that. And so we need to put a stop to this. We need to protect me and John Rowe for now. This has been long enough, and I've been here too many times, and we need to put a stop to this. If I don't get 100% of what was guaranteed to me by town meeting, I don't see how it is just or fair to me to allow this to continue. It's continued long enough. It has never stopped. The applicants have so much as admitted it, and yet everybody looks the other way, as if they have rights that I don't have. I have equal rights to what the Oldfields have. I haven't been there as long, but seniority doesn't give them any special rights. So I ask for the protection of my rights. Okay?
Thank you, Mr. Johannan.
Quick
Do you want to reply?
clarification. The 9-foot fence, yes, a fence was installed at 9 feet and had sound attenuation material put on it. The fence, an additional fence was installed 3 feet in with sound attenuation material. So there's now, in that area, there's now a double fence. Given the nature of the noise, it didn't make sense to me to say, well, take down the one that's at 9 feet, leave the double fence there. I think it provides additional protection.
Okay. Thank you, Mr. Prondak. Is there anybody else who'd like to be heard this evening? Dr. Dunn, do you want to come up here? Why don't you tell us your name and address, sir?
Sure. My name is Dr. Martin Dunn, live at 50 Briarbrook Street.
Welcome back to the Board of Appeals.
Thank you, with my wife, Carol. My choices tonight were either to correct final exams that I gave today are come before the board tonight, so.
Well, my question to you, Dr. Dunn, is did you make the right choice?
I'll let you know later. This is my 30th meeting before the board, before various committees here concerning this issue. My wife has attended 26 meetings. We have lived at 50 Briarbrook Street for 46 years. We built our home there. And our property runs from Parkwood Drive to Briarbrook to Barbary Lane. And all of this information is in the records from when I've spoken before, so I'm not going to go through this again. I'm speaking maybe, I'm not in a position or have the background to speak on zoning laws in town of Milton, and so it would be foolish for me to comment on those. But I have perhaps an editorial comment, and to me, and I've followed this very, very closely, it's almost, in my opinion, unconscionable that this can go on for a 3-year plus period of time, and I think it's 3 years or 3 years plus now since it started, close enough to say that. And it's certainly my opinion and my observation that this is a planned procedure to wear down the old fields, both from a financial viewpoint and from an emotional viewpoint, to where they will just throw up their hands and say, we cannot fight this any longer. I know that in the mitigation aspects, the old fields are over $200,000 that they've already spent in this. There are second generation in the business, and now their children would be a third generation in the business. And I just feel so badly for these people that this, to me, is not a fantastic situation. As many of you know, I have done 60 medical missions to developing countries. And if someone really wants to discuss lights where I go to the slums and work, there is not any electricity. We don't have to worry about water because they do not have any water. They get what they get in rain barrels. And is there noise there? There's plenty of noise there, 724. And I guess I look at it from a different viewpoint. These things, relatively, and I know this, they're relatively insignificant compared to what really can go on. And so I'm just making a comment. I just please to the zoning board grant the special permit. The Oldfields are honorable people. I've known both Bob Oldfield, the original owner, and his children. They've grown up with my children. And so I know them very well. They're going to do what they say they will do. They're honorable. It'll be done. But these people have young children growing up. They have the expenses of families. And they're getting to a point, I don't know, they haven't said this to me, but they have to be getting to a point where this is, as it continues, and listening to Matthew Dunn, Attorney Dunn here, no relation, tonight, talking about he's going to do this, this, and this. Now, I do not understand the legal aspects, but I'm adding up in my mind, I said, maybe that's another 2 years. I don't know, all of these appeals and everything that's going on. Mr. Joe Henning spoke about justice. That's not justice. Justice is to this family who have been there, who work hard They're on the third generation now. Their children are of age that they're being able to help around there. And I just, please, in justice to the families involved and what they've done for the community as recently as last Sunday, in which the whole community was there on their bazaar that they have every year for, 10 years, 11 years, something like that. What that does for families in the neighborhood. And my wife and I are one of 3 families, original families from that neighborhood that was developed and built. And so now the oldest one, I don't know if that's good or bad, in the area by age-wise, 4 months, 82 years of age. So I've seen all of these things. Become the historian, I guess, quote, historian of the community. People ask me about this and that. Please, in fairness to this family, I just ask you to grant the special permit that they're looking for.
Thank you, Dr. Dunn. We appreciate you coming, and good luck in your exams. Yes, ma'am.
Thanks.
Hello, my name is Carol Stalker. I live at 291 Hillside Street. I'm one of the abutters of the Thayer Nursery, and I have been for 35 very pleasant years. I've really enjoyed being next to them and found them to be excellent neighbors for 35 years. I guess when I see Mr. Johanig's lawyer here, Mr. Dunn, it brought back a memory, and the memory was when Mr. Dunn, for Mr. Johanig, subpoenaed me, and I went down to his office and answered hours and hours of questions about, have you ever received any gifts from the Oldfields? Have you ever hired the Oldfields to do any work for you? On and on and on. And I'd never been submitted to anything like that in my life, because I'm listening to how this is all about the Oldfields and how, the problem is the Oldfields. I'm in California visiting sick relatives, and my husband calls me and says, you've got a subpoena. So I go down there with my lawyer, who may be known to you, Judith Darrell Kim, and I say to her, is this normal? And she says, I've never heard of anything like it. And then I talked to the other neighbors. I don't know how many neighbors they subpoenaed. Maybe Mr. Dunn can tell you. But I think it was dozens and dozens of abutters and neighbors of the Oldfields were subpoenaed by Mr. Johanig's lawyer. Now, we have no problem with the Oldfields. The Oldfields are not intimidating us. The Oldfields are not bullying us. The Oldfields are not doing anything to us except being good neighbors. But there seems, at least according to my lawyer, that this is an extremely odd situation here and not within the norm. And that's all I have to say.
Thank you very much for attending tonight. Is there anybody else who wishes to be heard? Mr. Dunn, you can come up
This is a
for...
public hearing. I'd like to just sort of clarify the record here.
Sure, that'd be helpful.
Ms. Starker was identified by Maggie Oldfield in her answers to interrogatories in a civil lawsuit pertaining to a nuisance action between the Oldfield family and my clients as a person that had information about the activities and uses of Thayer at the Thayer Nursery site. I didn't pick Ms. Stoker's name out of a hat. She was specifically identified by Maggie as being a potential trial witness. Ms. Stoker received a subpoena to appear for a deposition in a civil case that was before a stenographer. She was sworn. She was accompanied by an attorney. And I'm more than happy to make the transcript available to this board or anybody in the town of Milton who would like to read it to indicate that Ms. Stoker was in no way harassed. She was asked questions that were directly on point that pertained to the civil lawsuit and the information that Ms. Oldfield indicated that she possessed. That civil deposition was undertaken at a substantial cost to my clients. and Ms. Stoker was eventually removed from the witness list by Thayer's own attorney as an individual who did not possess the information that Ms. Oldfield indicated that she did possess. And that was done as a direct result of the deposition that I was forced to conduct based on the interrogatory answers of Ms. Oldfield. So, again, I'm happy to make the deposition transcript available to anybody. I'm not in the practice of harassing anybody. I don't call unnecessary witnesses, and I don't schedule unnecessary depositions. So, with that said,
Thank you, Mr. Dunn. I don't think we want a copy of the deposition as part of this record, but thank you for your offer. Ms. Stalker, yes?
Ask Mr. Dunn, the lawyer.
I'm sorry. One problem you have to come up here to the microphone because they can't pick you up on TV. What's that?
We're going to get to the matter.
Yes, we do. We're going to finish this. This is going to be very short.
One thing that Mr. Dunn, the lawyer, did not say was how many other neighbors of the Oldfields did he deliver subpoenas to? I was not the only one.
Okay.
I know of a lot of people who got these subpoenas.
Okay, thank you, but that's not really directly relevant to our proceedings here. So if nobody else has anything further to say, Ms. McGettrick, do you have anything you want to, everyone's been talking, you've been sitting there in silence. Do you have anything you want to sum up so we can
Yes, several things.
move on?
Procedure,
Yes.
interesting question. That was one of the questions that was brought to me in October, and the Air Nursery hired me to work with the building inspector, try to figure out what the procedure should be going forward. It's very clear that the goal number one for Thayer was to finish the conditions that are required to be completed by their special permit. They understood that, at least as of your September 30th decision, and certainly they understood it from the building commissioner's enforcement letter. The appeal of the enforcement letter is based on the position that Thayer is taking, that they are in compliance with the conditions of the special permit. And compliance means substantial compliance. That's a term that's generally used for compliance with zoning. It means that it's a factual determination that, yes, indeed, is the job of the building commissioner normally, and will be in this case. The building commissioner has to determine whether the compliance is sufficient, it's substantial. And substantial, can mean different things in different situations. But what I've tried to point out to you here tonight in going through each requirement, and I provided detailed information about each, that's based on the exact language in the special permit. And when we did the site walk yesterday with Mr. Prondak, we went through those conditions in detail, including what types of trees, what types of shrubs, what type of fencing, what had to be done to the drainage. And the only conditions that are not completely finished are those that have been stopped because of weather at this time. they can only work from the date of the special permit, which is July 15th, 2016. They began working, and indeed may have done some work before then because it was a prior special permit. The time they knew they had even a decision was July 15th. That's the date from which you start to look at when they can actually begin to operate under the permit. So what do you do? What is the procedure? There's an outstanding enforcement order from the building commissioner. The applicant's position is that they have complied, and that's what they've come to you to say tonight. And so they're asking you to look at that issue of substantial compliance and to try to make a determination for the Board of Appeals that I don't know what the exact technical nature is of what you do with an enforcement order if you decide that it's no longer needed. I'm not sure what you call that as a Board of Appeals, but that would be step one. That would be what we're requesting. The next step is the applicant has to go to file a building, it's actually like a building permit request. He has to file a building permit request, and then the building commissioner must decide whether to issue, it's not a building permit, what is it called, Joe?
An occupancy permit.
I guess it's just called an application for an occupancy permit. They have to file that. Nobody's disputing that, and I've referred to it several times in my letter. They have to file it, and the building commissioner has to decide whether to issue it. So your decision is a layer, but it doesn't complete the process. And the reason I'm asking you and before you tonight on behalf of Thayer is that there is an enforcement order and that we had to appeal it. Because if we didn't appeal it, we would be saying, well, you know, it's true, we're not in compliance and as of now and forever forward. Well, the position of Thayer is that they are, that they have completed a very substantial amount of the conditions here. When you look at compliance and the way it's, you know, evaluated, when there's a situation like one in which the town has to give permission for an opening to be made to the street, and the town says you cannot do it now, that makes it impossible right now to do that particular part.
I understand that, but how do you respond to Mr. Joe Henning's comment that Thayer knew or should have known that the drainage issue
Well, because
was going to require piping into the sewer?
Well, because
in
you
a
don't
way-
do the
and-
piping at the beginning of the job. It's the end. It's the bottom of the drain. And they had to do the grading and do the retention area and put it, you know where it was going to be before. The last thing that they would do in that job would be to do the actual
Well, but
connection.
shouldn't they have known how long it would take them to put in the drainage system that they were going to put in, whatever it may be, and do that early in the process rather than later in the process?
I'm not sure they did know about the street opening.
Or maybe they should have.
limitation, Honestly, I mean, maybe they should have, but I happen to know about it because I was on the Board of Selectmen many years ago, but I'm not sure people are aware of that necessarily. When they went to do that, which was, I think, mid-October or late October, their question then was, well, we're not so sure you can because we think it's getting too late to dig up the street. We want you to wait until the spring to do that particular part of the job. And, the drainage area, the drainage grate has been installed and the drainage basin is in place. The drainage is being directed in the right direction and it will go into the drainage basin. The final connection to the town storm drain was the final part of the design.
I don't have the technical expertise,
that's-
engineering expertise. Let me ask Mr. Protnick a question on the drainage issue, which concerns me. If the storm drain is there and the topography has been changed by Thayer, do you believe that there is a serious risk of continued drainage onto Mr. Joe Henning's property, absent some catastrophic storm or some 100-year storm or something like that, so that based upon what is that has been installed now, is it your opinion that Mr. Joe Henning's property does not run any substantial risk of drainage going onto his property, and that the systems there are adequate, and the only issue is in the spring, the water that goes into the pool, the cesspool, or the drainage area is then shunted out through the sewer system?
My understanding of the drainage system is that it's primarily a surface drainage system. It's not a series of underground pipes, it's just surface, it's a grading of the land at the rear of Thayer Nurseries and the rear of the Joe Henning and the Tevens property. It starts at the Tevens property and gently slopes down towards Hillside Street. And the grading has been done the grading has been done entirely behind the Joe Henning property, Joe Henning Road property as of yesterday. And I was informed today that it was continued behind the Coles property today. My understanding...
So the grading is complete, in your
Grading
opinion?
is near complete, if not complete. My understanding of the purpose of tying into the drainage system is to prevent that new grading of the surface drainage system from flooding out Hillside Street.
Okay.
So, but I believe the significant amount of drainage is now directed away from the Joe Henning property. That's my understanding of it.
Mr. Dunn, do you want to be heard?
So just with regards to, if you want me to jump in.
Sure,
Just
please.
with regards to the completion date for the drainage system, as part of the civil settlement, Thayer agreed to complete, and this is a document that was.
Okay, but you would have to understand one thing.
But-
We know nothing about civil
I
settlements or
understand that.
litigation.
But
Great.
I'm making a representation to you.
Then we'll accept it.
that-
Go ahead.
That as part of the settlement agreement, there was a recognition by Thayer, an agreement to complete the drainage by December 15th. So to say that they didn't know that they had to complete it by December 15th is nonsense, because their signature's on a document that says they're gonna complete it by December 15th. So this is really something that is of their own doing, if they sort of get caught with regards to an inability to complete it based on the weather. This was on the radar screen since at least July of 2016.
Mrs. McGetrick, I don't want to put you on the spot here, but
Well, I think I've tried to explain it as best I can. There was a huge amount of work to be done. You look at at this drawing, you can see.
no, I understand what you said on that.
Fencing, drainage, and
What about
everything
the
else,
What
all
about
had
the
to be-
December 1st date?
15th, tomorrow.
Okay. Mr. Dunn is saying that there was some type of a settlement agreement and some civil litigation wherein Thayer agreed to complete the drainage system by December 15th. And that's in writing, and that's in the settlement agreement. Now, I know you weren't representing Thayer.
I don't know what that completing the drainage system means. I don't know what the settlement was. I really have to address this in terms of the special permit. I understand that may be an issue if it's an issue, but I don't know whether connection with the storm drain is a critical part of this drainage system.
Well, that's why I
It
asked
runs
Mr.
all the way
Prondak that
along
question.
here. The grading goes all the way along one side of the lot. It's designed to, as I explained, when I explained how it works, to prevent runoff from running in the direction of these neighboring properties, and that's been completed.
Okay.
And the purpose of the connection with the storm drain was something to protect the hillside street. That's what I'm being told. I really don't know about the technicalities of that part. And I would say finally that when you do a job like this, you do it, you do the length of it, you do the connection at the end. And they ought, I just don't, I'm not sure anybody knew when they would not be able to do that connection, or even what the timing would be of finishing the work. Because all of this work has been very time-consuming and it's taken a lot of time. I mean, they have to do all of these different things, and they've been doing them all simultaneously. I think it's remarkable how much they've accomplished. I'm not sure this particular question, that the decision should hinge on this particular question. I understand that.
That's my question, and I asked
It's a
it
good
because I know
question.
nothing about
It's a
drainage
good
systems.
question, but the reason for the connection to the storm drain doesn't seem to be vital to the drainage redirection,
Mr.
which
Dunn,
is.
and that's going to be it.
It'll be very brief. So the drainage plan that was agreed upon to be completed was actually incorporated the requirements of the special permit and the plans that Thayer themselves submitted. So it's saying Thayer needs to implement the drainage plan that Thayer said they were going to do and that Thayer agreed to do by December 15th. We didn't make up what they said they were
Right, but
going to do.
doesn't that
We
come
didn't
back
make-
and-
And we didn't make up the deadline. So Thayer said, and the reason why this drainage system it was asked for is because the drainage problem coming from Thayer caused hundreds of thousands of dollars of damage to my client's property. This was an extremely important provision in both the special permit discussing the bylaw, and then in the civil suit. So, this is something that, is been very important, that was of a top priority in both the issuance of the special
I'm
permit and
sure it
resolving the
was.
settle.
That's why I
civil
asked
suit.
the question.
And so it was, it was Thayer's plan, it was Thayer's deadline, and now Thayer didn't complete it because of whatever reason Thayer wants to come up with now. But they were supposed to do it by tomorrow.
Right. But Mr. Prondak told us that the purpose of the pipe is to run the water out into the street.
So we have, as part of this, we're supposed to have an engineer come out and evaluate the sufficiency of the drainage system. And that's supposed to take place sometime between tomorrow and the end of the year. We're trying to work out a deadline or a date that works for Thayer. And so that individual, who is an expert that has been selected and agreed to by all parties, is going to come out and make that determination. And in all due respect to Mr. Prondak, this is a pretty specialized area of engineering. And to say that, whether or not this is going to be sufficient, I mean, I don't know that. I'm sure Mr. Prondak has a better grasp of that than I do, but I'm sure it's not as good as the engineers that are going to be coming out to the property before the end of the year.
Okay, thank you very much. Okay, we're going to end the evidence part.
Just, yeah, I'm sorry. I just want to
Yes.
conclude, not summarize or anything like that. I just want to add that I definitely sat down with the building inspector and asked him to issue a certificate of, to decide that there was substantial completion and to take the route that has just been described to you. I said, is this something we need to go to the Board of Appeals for? Because a building commissioner is the enforcement officer. The building commissioner has the burden of evaluating the work on the site and deciding what's adequate in terms of substantial compliance. And so my first line of discussion, I guess I'd call it, was to talk to the building commissioner about approaching it that way. And then, depending on what he decided, at what time, I would then have...
I'm sorry, would you please put the phone down or leave the room? How about leaving the room?
Yeah.
You're talking on the phone now. We don't want to have you talking on the phone. Go ahead.
Then the process would have been a little different. We would have probably still filed the appeal, but of course, what I would have found, it would have been, one procedure would have been then to come to the Board of Appeals and say, now the building commissioner has decided X, Y, and Z, and so therefore the appeal is no longer necessary. Maybe he decides to withdraw his enforcement letter. Maybe he doesn't, and the appeal is still on. So, but this is... You are the board that the planning board decided would handle enforcement for, after an appeal or whatever was going to happen, not the planning board. So you're the board that's going to receive matters that, can't be decided at the building commissioner level and get appealed. And so we had the discussion, and the thought was that it would make more sense to do what's really the same process, but to come to you as a board and talk to you about it and see where you stood. And so I don't believe this is an improper procedure, because we have a right to appeal an enforcement order. I mean, the applicant has a right to appeal it, and he did appeal it within the 30-day time period. And the basis for the appeal was that he felt, the assertion is there's substantial compliance. We looked at the language in the September 30th decision, the discussion. We looked at what had to be done, and we've worked flat out. I've gone through it all already, I realize. But procedurally, I want you to understand that we discussed exactly what Mr. Dunn has proposed.
Yeah, I understand.
And we decided to do this instead.
Okay.
Understanding that we'd still have to go back and do the other.
Okay. Mr. Johanning, we're going to give you 1 minute, sir.
Okay.
1 minute. That's it. Go ahead.
This drainage situation it went for 6 months at the planning board. There were experts. DeSalle Burke represented Thayer, Eaglebrook Engineering represented myself and John. The two of them came up with a plan that was deemed to be sufficient to cure the problems on my property. But it's a complete plan. It's not 90% of a plan or 80% or 70%. It's a complete plan. Every piece of the plan was determined by the two engineering companies to be the cure to the problems on my property. And so 75% doesn't cut it. 60, 80, 95 doesn't cut it. Two experts, one representing Thayer, one representing John and I, came to a conclusion. I cannot accept anything less than 100%, because experts decided what was necessary to cure the problem. And so I have to have 100%. Thank you.
Okay, thank you very much. Okay, we're going to close the evidence at the hearing and discuss these. I'm sorry.
Did we need to talk about this?
I don't think so.
Was that one? Okay.
I don't know. It wasn't brought up.
Okay.
Let's see where we go. No, I don't think so. So we're going to talk about these issues right here and now. Do you want to discuss the procedural issue first? I think we should. Mr. Mullen, do you want to be heard? I know you've sat there in silence.
So this is really frustrating, right? Because every time we come to this case, we find out new facts, and we have testimony, and then we have more facts, and there are more facts on the facts. And while we have binders of materials, we don't know anything about these civil lawsuits, which appear to me to be pretty central to some of the issues. So that's very frustrating, and I feel like the board's in a situation where we're not going to be able to get this right. So I think we should have that on the record. With respect to zoning enforcement in general, I really feel like we've got to recognize our duty to the general public, to the owner, and to the abutters. And I really think that's a seminal zoning issue, and I feel like I want to get that out. We heard testimony on the difference between enforcement of the bylaw and enforcement of the special permit. I think this is about the special permit, not the bylaw. And I'm concerned if this is about the bylaw, then we don't have any facts in front of us about the bylaw. So I thought this was about the special permit. And that's a concern to me. I'm concerned about the time that this has taken, and I'm concerned about the procedure. With respect to the drainage, it seemed to me there was testimony, this is about use, right? The drainage problem is there. The real issue in the special permit is whether there's a secondary use here that can be, for which a certificate of occupancy should issue. We have a letter in front of us, the second letter, that says that the no landscaping work under the permit will begin until the drainage is completed. It seems to me that's a really important fact. But I don't know anything about the civil case. So I don't feel like we have all the facts to make that decision. Or maybe we do. I don't know. I don't know the interaction. I feel like this is a procedural nightmare for us with respect to the judicial proceedings that are ongoing. And I also feel like any decision, we're only going to exacerbate the procedural problem. So that's a long way of saying I am in favor of anything that simplifies this process for all concerned. And I'm not in favor of issuing decisions that are incomplete, lack fundamental evidence, and are made without all of the material facts we need. Because I thought that, I thought I heard a lot of work had gotten done, and I thought I heard an on-site inspection with the building commissioner that verified that. And so I'm very concerned about the procedure, John, and I don't quite know the answer, but I don't think we've got all the information we need to make an informed judgment the way we usually would.
Okay.
I could be persuaded. But.
Well, Mr. Deba.
I think I have to agree with that. I'd look at it a little bit differently, I guess. What's before us and what was appealed was the enforcement letter. And the enforcement letter said, as part of it, that it's correct, that the use of the property that was being made and was the subject of the cease and desist order required a certificate of occupancy, which hadn't issued. So in that sense, the cease and desist order would have been proper, whether or not the mitigation factor had been completed or not, which I guess it hadn't been at that point. A lot has been done since then. I really think that to have a proper record, I would think it would have to be in the context at this point of a certificate of occupancy as to whether or not the requirements had been met to issue a certificate of occupancy, and maybe based upon that evidence and the presentation on that, we might have adequate information to make the type of judgment that Jeff is talking about. But I kind of agree with him at this point. I'm not sure that we have enough. I mean, the drainage issue sounds like it could be significant, and the abutting neighbors certainly believe it's significant and have suffered some drainage damages, and it's of great concern to them. So I don't know. It's another one of these cases that has kind of morphed from a specific appeal to try to encompass other things, and I'm not sure that that's what we should be doing
I agree with that.
at this point.
Well, I guess I look at it a little differently, but, and that's because we have before us here an appeal of an enforcement order. Okay. The building inspector has told us that at least in his opinion, the conditions of the special permit have been substantially completed.
Correct.
That's his opinion. So if he so rules, or if he so decides, and he can do that outside of this hearing, then Thayer isn't at any risk, because he'd never enter an enforcement order if he believes that the conditions have been met. We have before us Thayer's appeal. I guess we can decide Thayer's appeal, but maybe Thayer wants to withdraw its appeal in light of the testimony of Mr. Prondak, and then we have nothing to decide, and then Mr. Dunn doesn't have to move to dismiss this, and Thayer then has to apply for an occupancy permit and go just the very route that Mr. Dunn is talking about. Because in all candor, I thought that the drainage issue was a substantial issue. And we know nothing about this agreement, we haven't read it, we know nothing about the civil lawsuits or anything like that, but we have to accept Mr. Dunn's representations to some extent. And I thought, by looking at what the law provides for substantial completion of a project, it requires that it be substantially completed, leaving some inconsequential items, punch list type items, in order to rule that there's substantial completion here. And in my view, I know the drainage problem. There are two issues in my mind. One is the noise, and I understand the applicant's issue on that, and I think that could be ruled substantially complete, but I'm not sure the drainage issue can be considered substantially complete under these circumstances. If the parties, as part of the special permit that was issued by the planning board, got together and had two distinguished engineering firms work out a solution, and I've been to Mr. Joe Henning's property when it was flooded, and this was so many years ago I can't remember, and it's still flooding. I certainly understand that he wants to rely on the engineering plan being completed, as apparently it was agreed upon by the two competing engineers, and it hasn't been completed, and for what reason, I know not. But those are the two issues that concern me here. I don't care about plantings and all of that. That doesn't affect the neighbors. I say it's noise and vibration and all of that, and then secondly, the flooding issue. So I'm not sure on this record that I'd be able to find that there was substantial compliance with the drainage issues. But those issues really haven't been defined before us. We haven't had the evidence. We don't have the engineering reports. We don't have the engineering plans. And so, in a sense, I agree with both of my colleagues that on that particular issue, I don't know, we have enough evidence to really make a finding. So it may very well be that this making findings on whether there's substantial compliance here or not on this record may not be the appropriate way to do it.
I would strongly urge us to not add to the record, because the record is too voluminous to begin with. I don't understand it. And I mean, I came into it in the middle of it. I learn new things all the time. To the extent that what the applicant's attorney is seeking is a sense of the board, my sense would be to remand it to the building commissioner based on these new facts, and for further consideration or for the issuance of a certificate of occupancy or consideration to that, and that we not rule on the cease and desist order based on the testimony we heard, which contradicted the letter that we got, and mostly contradicted, it seemed to me, because there were intervening facts between the date of the letter and the date of the hearing. And that feels to me like it's something that both the applicant and the party that is, the moving party, if you will, or the aggrieved party, or the person who's on the other side of this, or any way you want to say it, has asked for as well. It feels like the right place for us to be.
See, I'm not even sure, based on this record, and I don't want to ask, I'm not sure what extent of the investigation that the building commissioner has carried out with respect to the drainage system. I don't know whether he's seen the settlement agreement, whether he's seen the engineering reports, and I'm not asking that question, but it seems to me that that's a fundamental set of facts that the building inspector would have to consider in making rulings. And we don't have them here. He may not have had them. And what we're doing here is this is kind of an ad hoc, and I'm not being critical of Mrs. McGettrick, because I think she's done a wonderful job here, taking the building inspector out and showing him what's been done and all of this. But I'm not sure that is this type of sufficient evidence we should be considering on determining whether there's been substantial compliance. So I think I can be convinced that this matter should be remanded back to the building commissioner, allow the applicant to file an application for an occupancy permit, and go that route. And then if the parties can't agree, then I guess it'll be back before us. But initially, Mr. Prondak is our first line of defense in enforcing the zoning bylaw. And I think it may be better if he has the opportunity to have all of the facts on the substantial issues, and then he can make a decision. What do you say, Mr. David?
I generally agree with the concept. I still think that, I guess I'm hung up a little bit on the fact that if the cease and desist order is in part based upon the absence of a certificate of occupancy, then
Well, it is
Are we
very
required to-
technically, but he could file an application.
Tomorrow.
Mrs. McGettrick could file an application tomorrow
right.
and get a certificate of occupancy.
We
I'm
also
not
have
sure what the
intervening
procedure
evidence
is.
from the author of the cease and desist order. And to me, that's compelling.
Okay.
I'm not sure it's conclusive.
So
But it's
what, I guess
contradictory.
I guess my question is, what happens to the enforcement order if it's remanded? If we just remand the matter? Procedurally, just because I don't understand, and it's just something
Because you're in
that
a
popped into
appellate
my head.
trial lawyer, that's why.
Well, I would tend to think, unless, very technically, I think it remains in full force and effect until Mr. Prondak rules otherwise. And he could certainly rule otherwise, based upon what he's heard at this hearing, and issue a letter or say, I'm not going to enforce that, and file your application.
All right.
That's not within our jurisdiction.
But in the meantime, we don't add to the already muddled record here.
Right.
And we seek if we can get some clarification from the parties who are closer to it, and we'll take it on an appeal in a more informed manner.
Yes. Okay. So all those in favor of remanding this matter back to Mr. Prondak for further consideration on both the enforcement order and on any certificate of occupancy that may be sought, all those in favor?
Aye.
Aye.
Thank you for coming, folks.